Multimedia, Acción Empresarial presenta Gerencia para Todos con Rafael Nieves.
Welcome to Gerencia para Todos. In this opportunity with Diana Droulers, who is Executive Director of the Caracas Chamber Arbitral Center and President of IFCAI, International Federation of Commercial Arbitration Institutions. Welcome, Diana.
Thank you so much for having me.
And the first question is, what is arbitration?
Arbitration is a traditional figure that has been used throughout times, actually from Roman times, when it was thought that if you were in business and you were selling things, it would be much better if you had a problem to have an expert in business resolve your dispute instead of going to the traditional justice that the state gives its citizens. And it has been an evolution through time. Even in the medieval times, you had all these guilds that solved problems for their members. And then in modern times, I would say in the 20th century, at the beginning of the 20th century, after the First World War, arbitration came into effect because they were trying to rebuild Europe, and one of the ways to do it was to have business people from different countries go into contracts and sell goods from one country to the other, and obviously none of these wanted to go to the court. I mean, if somebody from Belgium was going to do something with somebody from Switzerland, the man from Switzerland wouldn't want to go to court in Belgium, and the Belgian person would not want to go to court in Switzerland. So they set up this system of arbitration, mainly in the International Court of Arbitration, which was in the International Chamber of Commerce. And then from then on, the United Nations structured the New York Convention, where it set the legal base for arbitration. And further on, they worked on a model law that has been adopted in many countries. So the fact is that instead of going to the justice that the state imparts, you're going to your peers in order to do conflict resolution.
And what are the advantages of arbitration for conflict resolution and the flow of the business?
Well, really, if you compare to the justice system in each country, it really is advantageous because it's much more flexible. It has much more specialized. In legal cost, time is money, so arbitration is much shorter than what a normal caseload before a court would be, and it's much more specific. It has people are able to choose their arbitrators who are people who are really knowledgeable within their field. So that makes it really more attractive. But what makes it most attractive, I would say, is the fact that even though the court systems have become more modern, judges are normally trained in procedural law, whereas in arbitration, all the arbitrators are each trained in whatever field they work in. So if you have a case in telecommunications, then you would have an expert in telecommunications resolving your case, and that would really make a difference. Then the other characteristic, which I think is very, very important, is that in modern times, you know, we're done with fax, we're done with telex, we're done with all these mail, sending everything by mail. Now you sign contracts, you have electronic signatures, and you sign contracts with just the push of a button, so that you need your conflict resolution to be as quickly and as modern as your business actually is. And the other thing is that since we have the model law has institutional arbitration, the fact that you can change the rules and institutions so easily instead of changing a procedural law makes it much more dynamic and able to sort of fit into the business world in the right way, with the speed that the business world actually works.
And to this date, how has been the evolution of arbitration?
In our country, it has been very well received. Actually, Venezuela signed the New York Convention, and then it signed the New York Convention in 1995. Immediately, the Chamber of Commerce in Caracas started a legal commission to study the possibilities of having an arbitration law in Venezuela, and we did go ahead and establish the parameters for that model law, which was taken to Congress in 1997 and actually adopted in 1998. And then, as of then, it has been applied. There's arbitral institution that works. There have been cases, there has been jurisprudence, and actually it's worked very well.
And how has the Arbitration Center contributed to the development of the field, including academic and professional education activities?
Well, you know, when you start to work in a field, you have to sort of sow the field so you can reap the benefits. So one of the first things that you have to do is promote the figure and the use of arbitration. When we started with the arbitral institution, obviously there was no contracts that contained the arbitration clause. So the first thing we had to do was teach people about the arbitration clause, what it should include, how it should be written up, which contracts it should be, and specifically tell people arbitration is a choice. You either choose to go to the normal tribunals or the normal courts, or you choose to go to arbitration. And if you wish to go to arbitration, you have to have a written arbitration clause. So from there we started to do, as soon as we had contracts and we started to have cases, we needed to train the arbitrators to solve the cases. Then you need to train the lawyers, not only the ones who write up the contracts, but the ones who actually have to use the arbitral procedure, which is a whole different field. It's the litigation field instead of the corporate field. Then you have to teach people in the academic part. You had to work with the students because obviously they're the future of the country, and they have to know that there's a new legal figure that's out there. It's a tool that has to be well used in order to work. And in fact, we have many activities that have done those things, particularly with the students. For us, it's been great fun, and we see that it really works. With the students, I've been taking for 8 years students to the William Viss Arbitration Moot in Vienna from 2 universities here. And then 3 years ago, we set up a program here, which we call the National Arbitration Competition, where we have a local case with local law and with the arbitration rules, because the moot in Vienna changes every year. It uses the rules of a different institution. So it's been quite fun, and I think the students are very motivated. We haven't been able to change the structure of all the law schools, but however, arbitration has been adopted as an elective in many law schools, and actually there's always, you know, somebody's always coming to the office saying, I have an interest in this, and that's very important, that the arbitration institution is a nucleus where everybody goes for information, be it information about arbitrators, information about what programs there are, information about what training is available. And that's very good.
And what international activities does the Chamber Arbitral Center me fui. How does the Arbitration Center work?
Well, the Venezuelan law provides that to have an institution, you have to have a director, you have to have rules, you have to have a list of at least 20 arbitrators, and you have to have a venue. So what we did was, in 1998, the Chamber of Commerce, Industry and Services of Caracas, which we call the Chamber of Caracas, set up an arbitral institution. And we did so based on the possibilities the law gave us. We set up our rules. Originally, the rules had provided for one procedure. Now we have new rules. They've been changed through time. They the evolution of the system has become much better with jurisprudence, with the experience that the parties and the clients have, the lawyers. And so now we have two procedures. We have a small claims procedure and we have our normal procedure. What does that mean? The procedure is quite simple. Of course, it sometimes becomes very complicated, but the normal procedure would be, ideal scenario would be, you go directly to the institution because you have an arbitration clause, and so you ask for your arbitration. And immediately we tell the other party that there is an arbitration that has been initiated against them. They have their notice, and they have the right, of course, of their answer. And so immediately the whole procedure gets into movement. Each party has the right, if they have a 3-arbitrator clause, each party has the right to choose an arbitrator, and then those 2 arbitrators will choose the president of the tribunal. If it should be only 1 arbitrator, then the parties should get together, or the institution names the arbitrator. And the procedure starts. What is very good is that you can only have 6 months, the tribunal only has 6 months to decide, and those 6 months can be doubled in time. So they would actually have 12 months if the case is very complicated and the tribunal so thinks. So immediately after that, you have your award, which is the results and what you're really looking for when you go to an arbitration. And that award has the exact same consequences as a judicial sentence that is firm, which means that immediately when you have your award, you can go ahead and execute that award and have no problem with it because the courts recognize it as such. So that's basically what a arbitral procedure, that's obviously oversimplified, but if I go into all the details, we would be here forever.
It's a basic.
It's the basic. The basic.
And what international activities does an institution have?
Okay, depends on the institution. Basically, when we started the institution, we said, we're not gonna do the invention of boiled water. We need to go and see who is working in arbitration and what is working in arbitration. So obviously our first step was to go to our neighbors and see who was the leader in arbitration in Latin America. And we went to the arbitral institution in the Chamber of Bogota, which worked very well at that moment. And we did 3 weeks in training with them to see what exactly does an arbitral institution look like from the inside. And then immediately after that, we saw that they had funding from the IADB, the Inter-American Development Bank, and we went to them for funds, which was really opened a big door for us because we were able to access the international world. We had a program in order to train the people in the arbitral institution, within the arbitral institution, in order to be able to manage the cases properly and manage the institution properly. So we did, and immediately we went to the International Arbitration Court, which is within the International Chamber of Commerce, and they were very generous, and we became their national committee. We based our rules on their rules, which have obviously been examined since 1923, which is when they started the arbitral court. And we became their national committee. Then we became the national committee of the Inter-American Arbitral Commission, the YACYAC. And we've signed agreement with other members and other institutions throughout the world, be it Singapore, Stockholm, South Korea, the LCIA, which is the London court. We have cooperation agreements with many of them. And that means that should any of them have cases, the cooperation agreements normally is a way to boost relationships and also a way to have a local cooperation in the cases, which means if you have a case where the venue is Caracas or anywhere in Venezuela, We would offer our chamber services, not only the conference rooms, but also the legal secretaries, any service of translation they might need, all that structure for a hearing, then we would provide it. And it's worked very well. And that is what brought us up to the International Federation of Commercial Arbitration Institutions, which is a great federation because we are 58 institutions that have gathered since 1985, and we've started working on what exactly problems do arbitral institutions have, the relationships of the institutions with the clients, with the parties, with the arbitrators, and in the end, although every single culture in the world is different, we have common problems which we have to solve and we have to find a way. And we have the lack of knowledge which would be very useful for all of us in our work. So we've gone with different projects. One of our first projects was the fact that we wanted to get rid of the added value tax because this is the administration of justice, and why should the tax be a burden upon the parties? We went forward with that, but obviously that's something that every single institution has to negotiate with their own local tax agency or government agency, whatever you would call it in that country. And then we went upon one project which is really great, which is the project of knowing what happens to arbitral awards once they leave the institutions. Because awards, although the institutions do not deliver the awards, it is the arbitral tribunals which go into the merits of the case. Every single award, when you see the jurisprudence, has the last name of the institution. So when you hear people talking, they don't say an award made by Dr. So-and-so. They say, oh, it's an ICC award, it's a AAA award, it's a Caracas Chamber award. And so in a way, we're given the responsibility. So we want to know what happens. When people have their award, they immediately go out. What kind of voluntary compliance is there? Is it normally you have figures between 80 and 60%? Then you have, do people settle after they have the award? Is the fact that they have an award and the other party may not be able to pay it at that moment, do they settle in that sense? Or do they go afterwards and you have to execute through the tribunals of the country where the award was issued? So there's a lot of things. Now we have a new project, which I think is wonderful because it's something that's not exactly for the institutions, but it'll make all the procedures work better, which is the possibility of having companies that provide certain services which are more expedient and which are better. I wouldn't say better, but easier to get to or faster to get to.
See, this is a competitive advantage.
It is because before, if you needed, for example, you have a lot of procedures where you need an expert or you need translators, and you would know there are certain people out there who are experts on very specific items. And through these companies, you can find experts in almost anything because that is exactly their job. So the institution doesn't have to lose time, which is precious to the parties, and it costs a lot of money. So that's sort of a database of all these things. Then translation. You have sometimes you have contracts that are even cases where you have contracts which are in different languages, and you have to know exactly what they mean, and it's very peculiar. You need translators who really know the legal language and are really into what the legal system is and what arbitration is. Otherwise, a small nuance or a difference in interpretation can really cause problems. So the institution does that. Then we obviously share a lot of information. And there's one very particular thing. We have a congress every 2 years, and this year it'll be here in Venezuela. which we think is wonderful. And we have 20 different institutions from around the world participating because we have the General Assembly.
Institutions like
Arbitration institutions. We have the Stockholm Institution participating. We have the ICC, which is the International Chamber of Commerce. The Secretary General will be here. We have the president, the new president of the American Arbitration Association. We have the Secretary General of the Milano Chamber coming. We really have a very good program on third-party funding and on different innovations that have happened throughout the world in the last year in arbitration.
Excellent. Well, Dr. Droulers, thank you for this interview and for the important information that you have to our program, Gerencia para Todos.
Thank you very much for having me.